Okay, good people. We should get started. It's around 9:25. We've given people some time to wait. So today we are reflecting on the conflict of rights. Okay. And the central argument in today's class is that because human rights are interdependent and immutable, the radical pursuit of one right, specifically, or a specific class of rights, may necessarily infringe on another right or class of rights. We need to assimilate that statement. So, because all that we are going to illustrate in this class is going to be illustrating that statement. Now, is there anything in that statement that you don't understand? Because if we don't get the central argument from the beginning, we will have a difficulty explaining or synthesizing the other part of the presentation. So I'd like to hear from you. What don't you understand in that statement? A word, a phrase, or what meaning do you derive from that? You can speak to me if you can, or type in the chat room.
Immutable.
What does the word immutable mean? Cannot be split. One cannot be broken from another. You cannot treat rights in silos. You would ask anyone in social work or even development studies people, usually when you start off dealing with health like HIV and AIDS, chances are you will end up in education because they are orphans sometimes to educate. When you start off in education of orphans, you will end up in dealing with health matters because they have sick parents at home or something. That's the essence. You will also realize that we have been largely talking about socioeconomic and cultural rights in this class, but increasingly you cannot talk about these rights without civil and political rights. As we will see subsequently, in making human rights work for people living in extreme poverty, you'd realize that the right to information, participation, etc. are relevant in the pursuit of those rights. You also realize that when we're talking about the right to water, when we're talking about the right to food, access included access to information, because access to information then allows people to effectively participate. So that's what we mean by interdependence and immutability of rights. They are sort of self-enhancing. It wouldn't be possible to deal with one right and ignore others because of that interdependence. So do we have anyone with an issue on that central argument? So we are saying that human rights are interdependent and immutable, and because of these attributes, if you choose to radically pursue or enforce one right to the exclusion of others or to the undermining of others, you will necessarily infringe on those other kind of rights or class of rights. I want to proceed as though we are good to proceed. Shall we proceed? Shall we proceed?
Yes.
Okay. All right. So we will now move on to illustrate this argument. Now, there is usually a conflict between private property regimes and public property regimes. Okay, someone would have a right to privately held land or a right to some other natural resources. But as you know, many natural resources are the preserve of the state. Actually, in some governments, you only own the surface. Anything underground belongs to the state, the minerals and everything else. So if you radically pursue your right to hold property without cognizance of public property rights, there will be a necessary conflict of these rights when the state radically enforces its right to natural resources without considering the adjacent right to privately hold land and other natural resources. There will necessarily be a conflict of these rights. Okay, so the state, if it's to enforce its right to these natural resources, if there are any people living on that land, it then has to proceed by way of compensation or giving them alternative land before it can put it to use. And an individual has a right to private property, and if the state has to take it, they have a right to claim that the duty bearers make alternatives available for them. Okay, so you could have community land and individual land, like accesses to rivers, grazing land, you know, collection of food and all this stuff. When you realize that there is a clash between individual rights and community rights, it is necessary to navigate that situation in a manner that allows for coexistence. Usually, the common law principle is that when you buy a piece of land or construct on a piece of land, if your land is on the way to the river, to the well for where people fetch water, or a forest where people pick twigs for cooking, or a swamp where they gather material for their crafts or mats, then you have a duty to create an easement. Okay, you have to make sure that you provide access to these common facilities, even though you have privately owned a certain space of the land. A number of infringements onto the MARA and the privatization of the game parks and all these things, they occasion that kind of conflict where individuals are denied access to some of the spaces they used to visit for purposes of either harvesting the non-timber tree products like herbal medicine, like the pests and the tree barks and things like that. Okay, so the radical pursuit of one's rights to use could infringe on private rights, or the radical pursuit of individuals and communities' rights to use could infringe on private rights, just as a private rights person or holding land could fence it off and then also infringe on the rights of the communities that have always had a right to use. The next right I'd like us to reflect about that generates a lot of conflict is the right to life. Article 26 of the Constitution of Kenya, 2010, actually around this time in 2010, people were busy campaigning for or against the Constitution. It was voted in on August 4th and promulgated on August 27th, the year 2010. Now, This article was one of the most controversial articles, partly because it demonstrated the conflict in a very fundamental civil right, which is the right to life. So we're going to spend a few slides illustrating where would controversy be coming from. So the article provides that every person has the right to life. The life of a person begins at conception. A person shall not be deprived of life intentionally, except to the extent authorized by this Constitution or other written law. Then it goes ahead in 26(4) to hold that abortion is not permitted unless, in the opinion of a trained health professional, there is need for emergency treatment or the life or health of the mother is in danger, or if permitted by any other written law. Now, to an innocent reader, one may not discover how conflicting this provision is. But when you see that the life of a person begins at conception, exceptions to that right are likely to occasion situations where this right is infringed upon. When we say that, in the opinion of a trained health professional, and I hope you guys are alert to the reproductive health care bill that has been debated in Parliament, in Senate, and religious leaders have been popping up to challenge it. It is largely because it is presumed that that bill is designed to amplify the ambiguity in this Article 26(4). What is the ambiguity? This provision talks of a trained health professional, not a registered medical practitioner. There are several trained health professionals, and the challenge would be whether they are able to form the opinion that an abortion is permitted. Okay? And then the grounds, so the caliber of the person who forms the opinion is reduced to a trained health professional, not a registered medical practitioner, who would be held at a higher standard. So the caliber of the opinion shaper or former is reduced. And then there is need for emergency treatment or the life or health. Now, doctors usually know what to do in emergency. They will save the life. They don't wait. They know what to do to save the life. But as soon as you say that health is a ground upon which this opinion should be formed, you are actually saying that the grounds upon which this opinion should be formed are increased. Why? Because the World Health Organization definition for health is the state of well-being, mentally, physically, socially, etc. Not the mere absence of infirmity. It would then seem that even the morning sickness, the throw-ups, nausea, and stuff like that associated to early pregnancy can be an issue treated as a health issue. Okay, the stress, okay, if the health of the teen mother is considered in danger just because they are conceived, then we can say that their health is in danger. Therefore, this opinion should be formed, or if permitted by any other law. Now you see, any other written law, any other written law. So the Reproductive Health Care Bill and its contents that regard termination of pregnancy would like to fill this gap of any other written law that amplifies the formation of opinions by trained health professionals, which when acted upon would necessarily infringe on the right to life. I would like to take some questions before I proceed. Have we understood that explanation? Have we understood that?
Yes.
Henry?
Yes, I've understood.
Okay. Mumina, the ladies, I need to hear you out. This issue touches you much.
Hello.
Yes?
I'd like to say something. Well, I want to know your thoughts on the pro-choice and the the debate that's not for abortion. What do you think about it, especially when we have women all over the world right now doing this movement called, can you shut up? This movement, this movement called pro-choice, like my body, my choice thing, whereby they're trying to legalize abortion and everything,
Well,
especially in the West.
I don't have, they are already here with us. I don't have so many thoughts, but mine is to demonstrate that our argument was a radical pursuit of one class of rights will necessarily infringe on another. So the radical pursuit of women's rights, sometimes we call it radical feminism, has a tendency to infringe on the right to life of the most innocent. Feminism sometimes, when it goes to its radical extreme, even undermines motherhood. Okay, so that's the point I'm trying to make in this class, that we are in a human rights class. You are going to be practicing with human rights practitioners. You ought to have an eye for which rights are you going to join in supporting and which rights are you going to be cautious about. Okay, essentially that's the point I wanted to.
I understand.
Yes.
I understand. By the way the world is moving right now, it seems like if you say something against the pro-choice debate and the legalized abortion debate, you're automatically classed as someone who doesn't consider women's rights.
Exactly.
A non-feminist.
Exactly. Exactly. That's what I mean by their radical pursuit of their women's rights position makes us, makes you, makes anyone else who would like to protect the unborn as anti-women. Okay, so, and even ourselves, if we choose to radically and fundamentally push our position, there are times when I'm saying our position because I belong to the side that thinks that life is sacred from conception to natural death, that any decisions that are to be taken ought to be able to protect both mother and child. Okay, and that we have the technologies to make this happen. So raising this issue at the forefront to let you know that the organizations you're going to be working with when you finish school, or some of you are already working with them, don't be surprised that they hold positions that are anti-life, because the groups that are promoting abortion and undermining family and sexualizing children, they have loads and loads of money at this point in time. So if you want to keep your funding, sometimes you might have to keep quiet. But if you are cautious and would like to promote that approach to human life and family that is valid, you would realize that it is safe to take this position that is protective of human life. So the women on the platform, some of the stuff I might raise might sound like it is anti-women, but it is just a truth that has been turned around, and a lot of noise has been said on the side of the lies. It is necessary that we point some of these things out. So, when the Constitution talks of any other written law, for sure we already had some written laws that were not as protective of the unborn child. On our law books up to now, Section 214 of the Penal Code determines when a child would be deemed to be a person. Okay, the Penal Code is the act of parliament that lists offenses and punishments. Okay, so Penal Code. So Section 214 of the Penal Code provides that a child becomes a person capable of being killed when it has completely proceeded in a living state from the body of its mother, whether it has breathed or not, and whether it has an independent circulation or not, and whether the nervous string has been severed or not. Okay? Essentially, this section, taken exclusively, would mean that you cannot kill a person before birth. Okay? This provision actually provides that way. Now, the Penal Code came into existence before the Constitution. Now, with the Constitution defining the life of a person begins at conception, do you realize that this portion of the Penal Code becomes redundant? Usually the Constitution takes precedence. So yes, there was and there is a defunct provision of the Penal Code that only says that you can only kill what has been born. And for sure, there was a case in 2004, a court case, the Republic against Dr. Nyamu and two others. Those of you who were adults of sound mind then, you remember that there was a bag of garbage that was found in Nairobi River by street children. But the garbage had unique contents. This bag had what looked like babies in there. So these street children raise an alarm, the police comes, and when it checks the garbage, it finds it has receipts and invoices that are all prescription notes that could lead them to where the garbage had come from. And it had come from Afia House in the abortion clinic of Dr. John Nyam. Okay, at Afia Center, I think somewhere near the bus park downtown, those of you who usually go downtown. So the prosecution chooses to prosecute Dr. John Nyamo with the offense of murder. They did not prosecute him for procuring abortions. They prosecuted Dr. Nyamu and two nurses for the murder of these several babies. Lady Justice Rawal acquitted, meaning he set him free on the grounds that the unborn children, the murder of whom the accused person was charged with, were, according to Section 214, incapable of being killed. So you realize that the prosecution, whether deliberately or not, chose to charge Dr. Nyam under Section 203, which relates to murder. any person who of malice aforethought causes the death of another person by an unlawful act or omission is guilty of murder. Okay? So prosecution chose a provision that would not stick or that would acquit the accused. Okay? So the prosecution, whether deliberately or not, whoever advised the prosecution must have known that the murder provision against an abortion situation would not stick because of 214. Lady Justice Rawal is also a known feminist, and she is also known to protect the rights of women. For sure, she has no fault in holding that position unless it influences her to make decisions that are against the right to life. She, in her judgment, ignored some important provisions of the Penal Code. Prosecution also ignored these provisions under which Dr. Nyamu could have been prosecuted. Section 158, to procure abortion. Section 159, the like by a woman with child. Section 160, supplying drugs or instruments to procure abortion. These provisions are still on the law books. They still exist in the Penal Code. They have not been deleted. Okay? These provisions still exist in the Penal Code. But Lady Justice Rawal and the prosecutors ignored these provisions, which, when put to use, would have convicted Dr. Nyamu and his co-conspirators. In her judgment specifically, she ignored to put to use the provisions of the Criminal Procedure Code. The Criminal Procedure Code provides that when a person is charged with the murder or manslaughter of a child, or with infanticide, and with an offense under sections 158 or 159, you see that? 158 or 159. If a person is charged under those provisions, and the court is of the opinion that that person is not guilty of murder, manslaughter, or infanticide, or under the provisions of 158 and 159 of the Penal Code, but it is obvious and clear that this person is guilty of the offense of killing an unborn child, he may be convicted of that offense, although he was not charged with it. Okay? So Lady Justice Rawal had provisions that would hold Dr. Nyamu to account and to have him convicted, even though he had not been charged with that offense before her. And when a person is charged with killing an unborn child, and the court is of the opinion that he is not guilty of that offense, but he is guilty of an offense under one of the sections mentioned above, that person may be convicted of that offense, although he was not charged with it. So it is clear that even if Dr. Nyamu had been charged with murder under section 203, but that under section 214, what he killed was incapable of being killed, but it is clear that he killed an unborn child, the Criminal Procedure Code then recommends he should have been convicted. But he was not convicted. And it is connected to the fact that his conviction would have been read by the women's rights movement as an anti-women action. As Mumina has said, my body, my choice. Why do you force me to carry a pregnancy? All these kind of thoughts are increasingly becoming popular and popularized amongst our people. And in the process, the woman is told the child is a bother, the child is a liability, the child is dispensable, so you can kill your own child for the sake of your career, for the sake of education, for the sake of this. Okay, so the rights of the mother being placed against the rights of the child who is vulnerable. So Lady Justice Rawal was, in her decision, was only reflecting her own ideological positioning as one who would prefer the enforcement and protection of the women's rights to choose an abortion, other than penalizing the abortionists who are making money off this egregious abuse to the right to life. Then came the idea of what we call reproductive rights. Reproductive rights were first defined categorically in the International Conference on Population and Development Program of Action. And it is those rights that embrace certain human rights that are already recognized in national laws, international laws, and international human rights documents, and what they call consensus documents. These rights rest on the recognition of basic rights of all couples and individuals to decide freely and responsibly the number and timing of their children, and to have the information and means to do so, and the right to attain the highest standard of sexual and reproductive health. So they talked about reproductive rights with the concepts of reproductive health and sexual health. So the term sexual was plugged into reproductive rights for the first time around this time. It also includes the right to make decisions concerning reproduction free of discrimination, coercion, and violence as expressed in human rights documents. Quite convoluted, but the pursuit of reproductive rights has accounted for a lot of abuses of other rights. Because, as you can see, Maputo Protocol is the protocol under the African Charter. Let me go backwards. When I ask you to check on the regional documents, I ask you to look at the regional documents. And we have the African Charter on Human and People's Rights. As you can see, they talk of human and people's rights, a unique creation for African peoples, because human rights in Africa is not individualistic, it is both individual and the community. So they talked of human and people's rights. A people can have rights. Now, Article 66 of the African Charter on Human and People's Rights provides that the state parties to the African Charter can enter into subsequent protocols to the Charter to emphasize and elaborate on deeper rights. Okay, so the African Charter allowed for entering what we call the Maputo Protocol on the rights of women in Africa. So it is the equivalent of CEDAW at the UN. At the African level, we have the Maputo Protocol. CEDAW is the Convention for Elimination of All Forms of Discrimination against Women at the UN level. So at the African regional level, we have this Maputo Protocol on the rights of women in Africa. And this protocol has a unique section in there, which when enforced, infringes on the right to life largely of the unborn. And it says, Section 14.2 of Maputo Protocol is saying that state parties are to take all appropriate measures to protect the reproductive rights of women by authorizing medical abortion. So the reproductive rights of women are to be protected by authorizing the killing of unborn children. And then they create the exceptions in cases of sexual assault, in cases of rape, in cases of incest, and where the continued pregnancy endangers the mental and the physical health of the mother, or the life of the mother or the unborn child. So what we have prohibited in our Constitution is now a right by virtue of the Maputo Protocol. And our Constitution in Kenya makes any international human rights instrument that Kenya has ratified part of the law of Kenya, even without domestication. The provisions of the Constitution evolved over years. In 2004, you remember, it is the same year when Nyamu caused problems there. We had the Boma's draft. The Boma's draft had Section 34, in which we had every person has the right to life. The life of a person begins at conception. So the drafters of the Kenyan Constitution inserted this provision. Very few constitutions across the globe insert this provision that the life of a person begins at conception. And then Boma's draft had this, number 3, as abortion shall not be permitted unless in the opinion of a registered medical practitioner, the life of the mother is in danger. Registered medical practitioner. Then a year after that, the Constitution evolved. It became Article 35, and they held that every person has a right to life except as may be prescribed by an act of parliament. They kept the provision, the life of a person begins at conception. And 3, abortion is not permitted except as may be provided by an act of parliament. So the Wako draft or the Cliffy draft, all were creating an opportunity for an act of parliament to take away what the Constitution has said. Every person has a right to life except. Abortion is not permitted except. Okay, so the drafters of the Boma's draft had inserted certain protective provisions that consequently were the subject of tinkering. Now, that is 2005. In 2008, we had the Reproductive Health and Rights Bill, which defined termination of pregnancy as the separation and expulsion by medical or surgical means of the contents of the uterus. The current bill of Senator Kihika does not calls pregnancy, it calls pregnancy the presence of a fetus in the womb. Of course, fetus is a biological term, but it is less respective of the person who the Constitution places in the womb. So the separation or expulsion by medical surgical means of the contents of the uterus of a pregnant woman before the fetus has become capable of an independent life outside the uterus. Now, this definition deliberately rejects the human status of the unborn by the use of the word contents of the uterus, okay, which can be emptied. We then moved closer to the constitution making. This is the committee of experts, chaired then by Nzamba Gitonga, and they harmonized all the previous drafts and decided that they will give us 2 sub-articles. Every person has a right to life, and a person shall not be arbitrarily deprived of life. They steered away from defining when the life of a person begins. They dropped that provision, and they also tried to avoid any ambiguity and controversies and debates that would come from except by any other written law or except in the opinion of. That's what they were avoiding when they proposed these provisions. Then the harmonized draft was revised in January 2010, and this is what we got. Politicians went down to Naivasha and tried to insist that every person has a right to life. They insisted that the life of a person begins at conception. They insisted that it be returned, that a person shall not be deprived of life intentionally, except as may be authorized in this constitution or any other written law, and that abortion is not permitted unless, in the opinion of a registered medical practitioner, the life of the mother is in danger. The reason I'm taking you into these cycles is every time the document was in the hands of a fewer group, a smaller group, the right to life of the unborn child was in danger. Every time the document was in the hands of a bigger group, a wider public, then the provisions protecting the unborn child are returned. The right of a person begins at conception, and the opinion is that of a registered medical practitioner. So by 29th January 2010, we are talking of the opinion of a registered medical practitioner. This is the document we now voted over. When it returned to the committee of experts, this is the document they gave us, and it is the current situation. You realize that they kept the life of a person begins at conception, but when it got to abortion is not permitted, the opinion was not that of a trained health profession. I mean, a registered medical practitioner. It was changed to read trained health profession. And as you can see, this document had said the life of the mother is in danger. Okay, this was done by members of parliament in Naivasha, people's representatives, but the committee of experts in a span of how many, let me see the dates, 29th January, between 29th January and 23rd February. Okay, between then and the publication date, which was 6 May, okay, there had been a shift from registered medical practitioner to trained health professional. There had been a shift from life of the mother is in danger to include health of the mother is in danger, and an insistence that any other written law could make abortion permitted. Okay, now again, the same ideological setup was existent in the committee of experts. We have someone who is a current member of the Supreme Court, Lady Justice who, I'm forgetting the name. And then we had Asango Chesoni there. there are quite a number of people who were known radical feminists who would do all they can to make sure that abortion is not restricted. Okay, and when you liberalize abortion in this manner of reducing the caliber of who forms the opinion and increasing the grounds upon which the opinion to abort can be formed, when you do those, you necessarily infringe on the right to life of the unborn person. I'd like to take any questions now before we proceed.
Hello?
Yes, please.
It's just something I noticed I want to say. I think this whole abortion debate and women's rights debate is strongly linked to reproductive rights. There's comprehensive sexual education bill that was trying to be passed.
Yeah.
I think it's like abortion is trying to be made into a form of birth control that's being advertised to women. Like, you understand what I mean?
Yes, I do.
So in my
Go
you
ahead.
wonder?
Go ahead.
I have a suggestion. I was trying to say, to prevent abortion, don't you think that we should have like a better sexual education, especially for children in Kenya? For not children but teenagers, because they're among the population that has abortion the most compared to older women.
Yeah. We will be tackling sex education down the road, but in the interim, I would like you to think about this. What kind of sexual education are you talking about? We already have some sex education going on. We know what mothers and aunties tell their daughters and nieces. We know what uncles and fathers tell their sons. And probably they may not be courageous enough to tackle the hard questions. Some people in the Philippines advised train the parents on how to talk to their children. Don't replace their parents with teachers. You would think of a curriculum on sexuality education that is developed by those who really care about the children. But from what you've seen, would you, for example, let an abortionist or a seller of contraceptives to design for you a curriculum for sexuality education?
No.
And exactly that's the situation where we are. The current comprehensive sexuality education curriculum that is being promoted has been drafted by those who would benefit from a sexualized generation. You get the challenge. They are not interested in asking young people to delay sexual activity. Their ideology, the sexual and reproductive health and rights ideology, is designed to increase actually sexual activity amongst young people so that they may demand the services that come along with that kind of lifestyle. Okay. Caroline, I need to listen to the women on the platform. Zaitwa, what are your views on this question? I could have sounded very hard on women. I need to be guided. Caroline? Zaitwa? Okay. Let's proceed. The next right that is likely to suffer from this kind of radical pursuit of a certain class of rights would be the family. So we have the family as the natural and fundamental unit of society and the necessary basis of the social order. Every adult has the right to marry a person of the opposite sex based on free consent. That is Article 45, 1 and 2. Now, Boma's draft and Wako draft had a provision indicating that a person shall not marry another person of the opposite sex. I mean, of the same sex shall not have married another person of the same sex. This provision was removed in the final draft. I'm not sure what the reason was for removing it, but it was removed anyway. Okay. And so we have parental rights and children's rights are likely to clash if one or other is radically pursued to the exclusion of the other. So we have these very good provisions that every child has a right to very many good things, and that a child's best interests are of paramount importance in every matter concerning the child. But these rights do not create any duties for the children, but they list a number of duties for parents without any rights. And yet we know that the Children Act, as it is right now, someone is in the chat room. Okay, let's find out. Okay, Caroline agrees with Mumina and says that lives of children matter. Okay, so anyway, so we have these parental rights that are likely to clash with children's rights depending on what ideology or mindset is enforcing the children's rights. Right now, the Children's Act as it is gives parents various rights, including the right to give parental guidance in religious, moral, social, cultural, and other values. But this disposition is missing in the Constitution, which prescribes children's rights and not parents' rights at all. Section 21 of the Children's Act gives children the duty to work for the cohesion of the family and to respect the parents at all times and to assist in case of need. Again, this disposition is missing in the constitutional provisions, which are only bent on prescribing children's rights and not duties, and ignoring completely parental rights. Okay, so that's the kind of clash that is likely to be occasioned. You're also aware that the African Charter on the Rights and Welfare of the Child in Article 31 says that every child shall have the responsibilities towards his family and society, towards the state and other legally recognized communities, and the international community. The child, subject to his age and ability, and such limitations as may be contained in this charter. But the child is also given duties in the African Charter on the rights and welfare of the child. The child has a duty to work for the cohesion of the family, to respect his parents, to respect superiors and elders at all times, and to assist them in the case of need. The child also has a duty to serve his national community by placing his physical and intellectual abilities at its service. So there are certain obligations placed on the child in the African Charter on the Rights and Welfare of the Child. But these dispositions are missing in the Kenyan Constitution when it began talking about the child. The child also has a duty to preserve and strengthen social and national solidarity, to preserve and strengthen African cultural values, to preserve and strengthen the independence and the integrity of his country, and to contribute to the best of his abilities at all times. Okay, so these are dispositions in the African Charter on the Rights and Welfare of the Child that tend to be missing in the Constitution of Kenya. Now, Article 26.3 of the Universal Declaration of Human Rights, those of you dealing with education are aware that parents have a prior right to choose the kind of education that shall be given to their children. The kind of education that shall be given to their children. Then Article 11.4 of the African Charter on the Rights and Welfare of the Child again affirms the duty of states to respect the rights of parents and legal guardians to choose for their children schools other than those established by public authority, which conform to such minimum standards as approved by the state, to ensure the religious and moral education of the child in a manner consistent with the evolving capacities of the child. Now, UNESCO, in collaboration with UNICEF, UNFPA, WHO, maintain that children have a right to receive instruction in sexual pleasure. They hold the view that children have a right to receive instruction in masturbation, homosexuality, amongst other things. Okay? And here we come to this thing called comprehensive sexuality education. There is a curriculum promoted by these entities under the guise of the prevention of unwanted pregnancy, under the guise of preventing coercive sexual activity, under the guise of preventing sexually transmitted diseases, under the guise of dealing with HIV. We have guidelines that are intended to drive sex education programs taught to children in schools worldwide that are consistent with what the parents would desire. We have some learning objectives for various age levels. And the learning objectives, according to UNFPA, is that when children go through this curriculum, we shall have removed the barriers to sexuality education, such as parental consent. So parental consent is considered a barrier to sexuality education in the mind of the United Nations Fund for Population Activities. That when children go through this curriculum, we shall have removed the barriers to accessing safe abortion services, such as third-party authorization requirements. So parental consent to an abortion procedure is considered a barrier to accessing safe abortion services, according to the mind of UNFPA. Barriers to accessing contraception, including emergency contraception. Now, I know some of the guys in university, the girls are in the habit of swallowing that P2 thing every Monday morning or every other time. So fellows are more scared about pregnancy than HIV or STIs. But yes, the understanding is when children go through this comprehensive sexuality education curriculum, according to UNFPA, we shall have removed the barriers to accessing contraception. Okay? So the promoters of contraception and abortion are the drafters of the current comprehensive sexuality education curriculum that we have. In their mindset, when this curriculum is implemented, we shall have removed barriers for adolescents in accessing comprehensive sexual and reproductive health services. Laws denying adolescents decision-making capacity or requiring that they obtain parental consent are considered barriers. And that's why you hear a lot this phrase, adolescent-friendly reproductive health services. They are considered adolescent-friendly because they exclude parents. Now, take it or leave it, with all their ignorance, with all their poverty, with all their errors and mistakes, parents always have the best interests of their children at heart. They may not know how to express it. They may have so many faults as individuals, but they always have the best interests of their child at heart. Finally, the United Nations Fund for Population Activities joined with 12 other UN agencies in a report showing how they are planning to advance the lesbian, gay, bisexual, transgender, intersex, and etc. They are up to 180 different orientations and their rights. Now, this is mentioned in an attached analysis to the UN Sustainable Development Goals that we did some time for the UN diplomats. Now, let's narrow down a little bit to these learning objectives. Now, we are at the level of children's rights, emphasized in a manner that kicks out parents out of the equation, okay? The radical pursuit of children's rights that kicks out parents out of the equation ends up undermining the family, ends up undermining life, okay? So this is the point we are developing. We are illustrating that the radical pursuit of a right or class of rights has a tendency of infringing on another right or class of rights. So for children aged 5 to 8, learning objectives include girls and boys have private body parts that can feel pleasurable when touched by oneself. Okay, this is the guideline of developed by UNESCO and these other entities. Then between 5 and 8, the children needs to know that bodies can feel good when touched. And masturbation is actually not harmful, okay? It just has to be done in private. You know, people have been asking, what is this CSE curriculum that you people don't want us to look at? Essentially, this is some of the content. CSE learning objectives for various age levels, 9 to 12. Okay, 9 to 12, this is a little bit into adolescence, but still early adolescence. So we are saying that both men and women can give and receive sexual pleasure. We are telling them that relationship between excitement and vaginal lubrication, penile erection and ejaculation. Many boys and girls actually begin to masturbate during puberty. So it is a learning objective. They need to learn that many boys and girls begin to masturbate during puberty. And then we can also define the function of orgasm. Okay, now look here. These are 12-year-olds, these are 11-year-olds, 10-year-olds, and we are giving them all they need to be sexually active, other than finding a language that allows them to respect themselves and consider probably. Now, this is 9 to 12-year-olds. Who received this information amongst us on this call at that age? Is there anyone who had the opportunity to receive this kind of information? You can do it in the chat room or you can talk to me. Okay. Is it a very sensitive topic? You are social workers, you are development workers, you're going to be working in the communities. Do you consider this very sensitive to talk about? Mina, I know you have
Hello?
children in the background there. Are you going to be teaching them this way?
Oh, they're watching TV. They can't hear me.
Yeah.
Okay, at our age, at 9 years, 10 years, 12 years, we had nothing like this, especially when it came to reproductive education. And I don't consider this CSC reproductive education because it's more of sexualizing children and giving children, I don't know how to say, but I'd say it's a dirty mindset.
It is preparing them to be consumers of certain services. Now, you realize that nothing has been told these children about their menstrual health.
Yes.
No one is telling them about their fertility.
Yes.
Okay? Because usually by around 9, 10, 11, if the menses are to start, then we need to be telling the young people about the fertility cycle and to see those other several symptoms associated to being a woman. Okay?
Mm-hmm.
But children who are being taught that sexual pleasure is a right, masturbation is okay, and all these things, chances are this mindset is only to prepare them to be sexually active, not to be respecting their fertility and treating it as a good that ought to be spared for the right time. At between age 12 and 15, people would learn about both men and women can give and receive sexual pleasure with a partner of the same or opposite sex. Same or opposite sex. Everyone is responsible for their own and others' partners' sexual pleasure and can learn to communicate their likes and dislikes. Now, these are things I talk to people preparing to get married about. And this curriculum would like that kind of talk is given to 12 and 15-year-olds. Finally, at this age, they're telling them that access to safe abortion and post-abortion care is a right, referring them to clinics. Actually, in the situation we just had of increased teen pregnancies, the mindset of this curriculum would be increase the provision of abortion services. The mindset of this curriculum will not be increase crisis pregnancy centers. It will not be increase the number of homes that will take in these girls so that they can carry the baby to term. This curriculum is designed to prepare young people to demand for abortion services. And that in case the abortion went awry, they can also seek post-abortion care in various hospitals. Okay? And this is the radical pursuit of a skewed or flawed children's rights, or right to education, or right to information. Okay? This will be pushed under the right to information. Let the kids know everything they can know. Don't distill it. Don't add any values in it. It should be value free.
Okay, sir.
Yes.
My concern is about prepare them psychologically about maybe their clothes. But it is a time when a parent cannot control the boy, a culture. So he is introduced to family planning. So for me, is to give her okay to do, because he knows even if I have sex, I will not have pregnancy. And now that increases the number of maybe prostitution or early marriage or transmission of diseases, because a child knows that I will not get pregnant because my mother has prevented me through family planning. Also, I was against this issue of contraceptions. whereby the government will say, go to all health centers, there is contraception, like condoms, I mean. So it's like to say that you are okay to have sex pleasure anytime you have, as long as there is contraception. So it's somehow good, but also imposing them to do it.
Mm-hmm. Yeah, as I told you earlier, the comprehensive sexuality education curriculum is the tool for the promotion of sexual and reproductive health and rights. You are human rights students. You remember we talked about the rights-based approach, which creates duty bearers and rights holders. The comprehensive sexuality education curriculum is to turn the children and young people into activists for sexual rights. Okay, so essentially there is going to come a time when most of the young people who've gone through this curriculum, they have a right to sex as to the pleasure that comes out of sex, and that they have a right to demand that the state creates a policy and legislative framework that allows them to enjoy sexual rights. And in the process, they will not be able to hold on to the discipline that the rest of us could have been raised in. I hope you are aware, some of you are social scientists, you know that the age of sexual maturity comes almost 10 years earlier than the age of social maturity. Usually by 9, 10, 11, kids are getting the secondary characteristics that prepare them for sexual maturity, but we only expect them to be socially mature after 18 or 21, or, actually, we are advised that the brain matures fully by age 25. So socially, we expect these young people to take up responsibility socially way after the 20s. Okay, yet they are sexually mature earlier in life. So these entities that would like to sexualize children ride on that gap by providing this kind of stuff and infusing it in law and policy. So when you hear people screaming against Senator Kihika's reproductive health care bill, you would understand where they are coming from. You'd be able to discover the challenge incumbent in the radical enforcement of sexual rights, the radical enforcement of reproductive rights, which necessarily infringes on the right to life, it infringes on the right to family, it infringes on parental rights, and actually destroys children in the process. Do we have any other comment? So as a development worker, as a social worker, whichever organization you're going to be serving, the community you're going to be serving, you will always see organizations that look at reproductive rights and sexual rights in this mindset. All you have to do is to be alert enough to be able to guide your community in the more sustainable approaches. There are alternatives to comprehensive sexuality education. We have the sexual risk avoidance curriculum, we have the human dignity curriculum, and several other proven curricula that are able to offer alternatives to comprehensive sexuality education. You also have to school yourself in a mindset that as soon as a preborn child is involved, you need to take sides with a preborn child. For sure, the woman might be in a difficult situation. It could have been a rape. It could have been incest. It could have been sexual abuse, for sure. That is terrible. But a woman is better liberated when they are cancelled out okay, journeyed with psychologically to deal with the trauma of the incest, of the rape, the betrayal of the incest, have the baby to term. And if they don't want to keep the baby because it reminds them of the abuse, let's give the baby up for adoption. These alternatives exist. So as a social worker or development person, we need to be figuring out how do we establish crisis pregnancy centers? How do we make sure that anyone who gets pregnant, when they are not ready to be pregnant, is protected because she has already become a mother. And we need to protect them because by protecting them, we protect the life in their womb. Now, these entities interested in distributing contraception and abortion are not interested in this kind of thinking because it won't promote the consumption of the services available. Contraception, abortion gadgets, and all these things. On the extreme right of sexual rights, we have the transgender community that is aggressively pushing for rights to have children. Men would like to pay women to have children with them. So gay couples would like to pay women to carry babies for them in assisted reproduction. And they would like the states to pay for this lifestyle situation. We also have a high dependency on hormones by the transgender community. Someone wants to be a woman all through, so they need hormones to keep their voice feminine, to suppress the growth of beards and all that stuff. And they would wish that the state pays for this kind of lifestyle. Or women who would like to be on hormones for the male hormones and things like that, so that they can look like men. And they would wish that in the area of sexual rights, the duty bearers, which is the state, would have to use taxpayers' money to sustain that kind of lifestyle. Okay, so that's the situation in which we are, and we ought to be cautious enough to know that these kind of rights exist and know how to deal with them. It doesn't mean that we should be discriminatory against people who turn up to be LGBTQ, but we ought to be open to the idea that they are a highly wounded community that needs to be helped to recover from that woundedness. Okay, yeah. So, do we have any other submission? Okay, so today we are done with the conflict of rights. We have one more class on minority rights, and then we start presentations. I hope people have had an opportunity to go and visit the informal settlements. Umenyamanza. Hilary, your microphone is on.
Yes.
Have you improved your presentation?
I'm working on it, yes. I can.
Okay. Mumina? Henry, is your presentation ready?
I'm finishing on it.
You had the opportunity to go to the informal settlement?
Yeah.
Okay. Okay. So it doesn't seem like there's any. Caroline, you want to say something?
Yeah, I'm good. I've already finished the work.
You're ready to do the presentation?
Yes, but there's some points I left out. I'm just gonna fix it.
Okay. There is a possibility we will start presentations next week, part of the presentations next week. Yeah. Now, I'm still concerned. You are more than 20 on the platform of Melim, but very few are coming to class. What are we going to do with them? How are they going to be part of the presentations? What do they tell you? Hilary?
Sir,
What do people tell you as they are struggling with?
this week I never communicated, but some they were working on it.
No, I'm saying, what challenge are people facing for not coming, if that makes them not come to class? We've never been more than a third in this class.
Some they talk about internet.
Hmm.
So that's the main issue. They cannot access internet.
Yeah, but I see they go to the Melim I find they access the Moodle platform. When I check, I see almost every one of you here has had access. Some 2 days ago, others 3 days ago, whatever. Anyway, we will let that pass for now, but it might be difficult for people to get assessed. Yeah.
You'll just inform them the next class is critical because it's presentation. They prepare themselves in advance to attend.
So you can follow up there, SDS and SSW, and we see if people, but at least we are putting the recordings up. I hope people get an opportunity to listen in. That's why when you people don't ask questions or comments, you will be doing a disservice to your colleagues, because you ought to be the sample feedback on how the learning is going. So sometimes it is necessary that you actually are interactive in the sessions. Okay, so I think we can end here for now. No, someone has typed in the chat room. Let me see what they're saying before we go. Due to COVID restrictions, some of us are not able to visit informal settlements. Zaitwa, that is not honest. Zaitwa, where do you stay? We start with where you stay. Zaitwa? You're in Malawi right now? Okay. And Zaitwa, what right are you working on? Education. This information on education you can get without going to an informal settlement. You can interview 10 households, 10 poor households, wherever you are. Either you call up the rural folks or whoever, just get 10 informal, 10 poor households and interview them. You should have something to say. Okay? So, okay. So since there is nothing else to be said, allow us to end here and let's meet next week.